Hello friends, in the series on the income tax cases, today we will discuss the case of Mrs. Malini Ravindran versus Commissioner of Income Tax Appeals and others. This case has been reported in 457 ITR at page number 401 and the matter has been decided by Madras High Court and the date of the judgment is 14th November 2022. This case is a perfect example that how the law written can be very dangerous for the assessee and it can have a huge tax implication or interest application for the assessee, even if the assessee do some mistake or if some decisions comes against the assessee and if the law is interpreted in a very strict sense. This case is also an example that how words are important which are there in the Income Tax Act. In this case, the assessee sold a property through a memorandum of understanding dated 12th December 2010. The assessee received the sale consideration in the 3 financial years, that is financial year ending 31st March 2010, 31st March 2011, 31st March 2012, and accordingly the assessee calculated the long-term capital gain in the 3 financial years and paid the taxes in the 3 respective financial years. When this case was under scrutiny before the learned assessing officer, the assessing officer calculated the whole tax in the financial year 31st March 2010 and created a tax liability in the financial year 31st March 2010 and calculated the refund in 31st March 2011 and 31st March 2012. The assessing officer adjusted the refund of 31st March 2011 and 31st March 2012 with the tax liability of 31st March 2010. As far as this much is concerned, the assessee do not have any objection because it was tax neutral. But when the assessing officer sent the notice for the recovery of the interest under section 234B, which was a hefty amount in this case, amounting to rupees 19.43 crore, because in this case the sale of the property was above 100 crore rupees. So it has a huge impact of section 234B interest liability. When the assessee received this notice, although in this case the assessee didn't challenge the year of taxability of the capital gain, but when the assessee was made aware of this tax liability of the interest, because technically the assessee has to pay this interest, the assessee filed a application before the Commissioner of Income Tax for waiver of this interest. The assessee was relying on the words of section 234B. 234B section is there, which is about interest for defaults in payment of advance tax, and which says that all the taxes which have been paid, whether under section 140 capital A as self-assessment tax and any other sum paid otherwise, that should be considered before calculating the interest under section 234B. So the assessee was relying on the second limb of section 234B subsection 2, that is any other sum paid otherwise, because the assessee has paid this amount in 2011 financial year and 2012 financial year. So the assessee was saying that any other sum paid otherwise includes the amount paid by the assessee as advance tax in the financial year 2011 and 2012. But the Commissioner of Income Tax was not convinced with this thing, so he go ahead with the levy of the interest under section 234B. So the assessee was before the court. The Madras High Court said that any other sum paid otherwise should include the payment made by the assessee in the financial year 2011 and 2012, but at the same time gave a rider that this tax should have been paid by the assessee in the financial year 2010, but in fact this tax has been paid in the financial year 2011 and 2012. So the assessee has to bear the interest for 1 year, that is 31st March 2011, and for 2 years on the amount which has been paid in 2012 and not for the entire period. So in this case, the assessee got the partial relief. The department was calculating the interest from 2010 up to the date of the order, but the High Court restricted this interest for 1 and 2 years respectively. At the end of this video, once again I am repeating the name of the case. The name of the case is Mrs. Malini, Ravindran versus Commissioner of Income Tax, Appeals and Others, and this case has been reported in 457 ITR at page number 401. The matter has been decided by Madras High Court and the date of the judgment is 14th November 2022. Thank you, friends.